Welcome to the final session of this three-part series of expert talks focusing on patent portfolio strategy. My name's Ian Jones. I have a background in pharmaceutical research and I'm a chartered UK and European patent attorney at Gill Jennings Every in the chemistry and life sciences team. The patent lifecycle can be split into three parts. The first is preparation, which we looked at in part one of the series. The preparation phase looks at preparing your company for its IP journey. It provides a set of fundamental processes that you should consider implementing to help capture innovation within your company to ensure that it can achieve its commercial goals. The second is the implementation phase, which we examined in part two of the series. This includes processes and strategies used to generate registered patent rights. The final section, which we'll now focus on, looks at monetization. At the end of the day, this is what it's all about. We're going to discuss the common ways to generate revenue from your IP and make it work for you. One of the main reasons for getting a patent is to make some money out of it, a return on your investment in IP. There are a number of ways in which you can derive revenues from your patents, but the main ones are licensing or pooling, or selling your IP. The last thing I want to talk about today is revenue derived through enforcement. Licensing is essentially an agreement that you allow a third party to infringe your patent and take no action against them in return for some sort of compensation. This could be a set amount per year, or more typically a percentage of their gross sales. As a rule of thumb, you should be expecting to get around 3 to 7% of gross sales as a royalty. However, the exact amount is dependent upon the specific sector and market influences, and especially how good you are at negotiating. Licenses can be drafted to fit your business plan. They can be of any duration, they can require certain milestones to be met for them to remain in place, and they can require minimum annual payments. They can also place restrictions on certain products, certain fields of technology, or even certain global territories. They typically come in three flavors: an exclusive license, a non-exclusive license, and a sole license. An exclusive licensee is the only entity allowed to use the invention, often precluding the patentee from using it, whereas having a sole licensee may still allow you to work the invention. You can have more than one non-exclusive licensee. But obviously, the compensation you receive from the licenses will be heavily dependent upon the type of license granted and the terms of that license. A lot of SMEs consider licensing as an option, as they can derive revenue from their patent assets without investing in tooling up or manufacturing the product themselves. They can also make use of a third party's existing distribution channels and suppliers, their customer base, and their brand. SMEs in the pharmaceutical sector typically look at partnering projects after initial drug development to avoid the substantial costs of clinical trials. In any case, certain sectors look at cross-licensing as an attractive alternative to avoid all parties from being excluded from markets. Pooling is an efficient way of dealing with mass licenses. By pooling patents, licensors and licensees are able to mitigate a lot of the costs involved, together with the need to negotiate with multiple license holders. A great example of patent pooling is OneBlue LLC. Launched in July 2011, it's a one-stop shop for the Blu-ray disc industry, representing around 15 licensors and covering more than 10,000 essential Blu-ray patents. However, not all pools need to be that deep. You can also sell your patents. This is really cashing out of the game. You can simply decide that you'd rather have the money up front and dispense with having to administer licenses. This is common following mergers and acquisitions, when a reshuffle of commercial plans may result in redundant IP. In any case, you could always include a self-license when selling the IP so that you can continue to carry it out yourself. Monetizing your patent portfolio requires you to know the true value of your IP. This is not an easy task. However, there are three main methods which can help. The cost method valuation is based upon the costs that you have incurred developing the technology. A potential buyer can avoid these costs by purchasing the technology directly from you. The market value method looks at the value of your product in the marketplace based upon its recent track record or by assessing its the recent sale or licensing of similar products. However, it can be hard to find published data for other IP transactions as they're usually confidential. There are third-party companies that can help you achieve this. The income or economic benefit method predicts future revenue generated by your IP and factors in risks and financial costs to give a net present value. But however you want to monetize your patent portfolio, you'll want to be sure that you understand its true value before doing so. The last point I want to talk on is about enforcing your patents. This shouldn't be thought of as a revenue stream, and I've only included it so it's on your radar. However, as enforcement is more of a way of protecting your market and therefore indirectly protecting your revenue stream. Litigation should typically be avoided if at all possible, and you'll often find that negotiating agreements or settlements with competitors will typically be in everyone's interest. So this brings us to the end of the final session. We've explored how your patent portfolio may be monetized so that you can start to see a return on your investment in IP.